I'm Mike Lacourt, President of the Association of British Investigators, and today we're going to be discussing the UK ABI's GDPR Code of Conduct that was recently approved by the Information Commissioner's Office. This development is significant not only for professional investigators, but for law firms and general counsel, compliance and risk professionals, and because it provides a trusted sector-specific framework to manage data protection and third-party risk when instructing investigators. Joining me to discuss the code's journey, its implications in the legal sector, its purpose, I have Tony Yamossi and Katie Hewson.
My name is Tony Yamossi. I'm the current Secretariat for the Association of British Investigators and the author of the ABI's UK GDPR Code of Conduct for investigative and litigation support service providers.
I'm Katie Hewson. I head the data protection team at the law firm Stevenson Harwood.
Okay, so Tony, just to set the scene for the legal investigators here, and all the listeners that are here, could you provide a brief overview of the private investigation industry in its role in litigation support primarily?
Yeah, Mike, the first thing to bear in mind about our sector, the investigation sector, is that all their activities have the potential of being used in evidence, and that's the lawful activities I'm talking about. And of course, invariably, the activities involve the processing of personal data. No matter what an agency might say that they're just corporate investigators, companies are run by individuals, and that's processing personal data. But there's no central compulsory registration for investigations in the private sector in the United Kingdom, despite the industry having existed for over 200 years. The industry is made up by usually second career or third career individuals. Quite a few of them come from police background, military background, but they do come from all types of society and commerce. Many come from the legal, insurance, and other professions. And collectively, as an investigation group, they provide a lot of services for the legal profession, which is the major source of assignments for the industry, whether it be in mostly a contentious business, whether it be simply litigation support like interviewing witnesses, process serving even, or scenes of some torture issues, or in contractual issues. Also, the work in fraud, quasi-fraud, domestic scenarios, for financial ancillary relief proceedings in divorce, all sorts of type of services that the legal profession look to for the investigation sector. You could summarize it in a couple of words, or just one word: troubleshooting for the legal profession. That's what we do. And its makeup is something that comes to the attention of the government about regulation, but regulation at this time doesn't exist.
Thanks, Tony. So, Katie, before we go into the legal reaction to this code of conduct, could you explain your role during the process in supporting the ABI's code of conduct to approval?
Okay, yeah, it might be useful just to kind of start with what a code of conduct actually is. So, as Tony's explained, when investigators are doing their jobs, there will be quite a lot of personal data that is involved. So, that's information about individuals. And UK data protection law applies to that. And you have to fulfill several different obligations whenever you are handling information about individuals. It can be particularly tricky to comply with data protection law in an investigations context, and that's because it can be unclear who's got what roles and what responsibilities legally. It can be really tricky to comply with the need to be transparent about how you're processing when you're obviously doing things secretively. So what the UK GDPR, that's the data protection law we have in this country, allows for is for a representative body to draw up a code of conduct to explain how to tackle things in that particular sector. And that's what has been done here. The ABI has done it. And it's a fantastic achievement. It's the first GDPR code of conduct that we've got in the UK. And the ICO, that's the data protection regulator, their announcement, I'm just going to read when the code was approved. They said codes of conduct are an excellent way of helping organizations demonstrate data protection compliance and protecting people's data rights. They enable organizations to address and resolve any data protection challenges whilst also providing transparency and regulatory certainty. So, I mean, that's absolutely fantastic. The regulator there for data protection is saying this is a great way of showing that you are compliant with data protection law when you are carrying out an investigation. Coming on then to my role and Stevenson Harwood's role, we didn't draft the code. That was very much a lot of hard work, particularly from Tony. But we helped to refine it in response to some of the ICO's comments. There was a long process where the regulator looked through the code. And for example, initially, there were lots and lots of different issues that the code was going to cover. The ICO advised that we narrow those down to some of the really important issues that people often struggle with in this context. So roles and responsibilities, what role does a law firm have? What do they need to do? What does the PI themselves need to do? Data protection impact assessments, how to carry those out, and how to ensure that people's rights are fulfilled, even though it's quite a tricky situation when you are investigating someone without their knowledge.
Thanks, Katie. So, Tony, you developed the ABI's GDPR Code of Conduct, and it's quite a big, substantial piece of work that took several years of commitment. What was the motivation behind creating this code?
Well, Mike, the work really started 25 years ago, on the 1st of March 2000, when the 1998 Act came into force. And it was a suggestion then by the Deputy Registrar, he became a commissioner the following day, said that the ABI should put together a good practice guide. And we went away, we thought about it, and we did. And we put one together. It was the foreword and was written by a previous information commissioner, Elizabeth France. And we relied on that. And in fact, we made an entry exam for ABI membership based on the contents of that guide. And we pursued that in earnest. We then moved the entry level for ABI membership elsewhere. And of course, then GDPR came in. And when we saw it on the horizon, post 2016, we started to realize that there were some serious changes needed within the sector. And we started to provide some training. Workshops discussing with PIs, not just ABI members, but those outside, on how the investigators could approach and continue their services, particularly for the legal sector, whilst remaining compliant. And it became apparent that there were some key issues that the sector were struggling with. And of course, then came the implementation by the Information Commissioner of the code scheme. And that was the perfect opportunity for us to embrace what we'd learned from the workshops and put it into a code. And so the work started with the Information Commissioner's office to develop what ended up last year as the final approved version.
Okay, and so it started pre-GDPR then?
Yes.
And just sort of legally to explain that, the principles here have been the same since the 1998 Act and actually before that, in terms of, you need to do things lawfully, you need to do things transparently and fairly. But the actual, I guess, two things changed when GDPR came onto the scene. 2018 was when it came into effect. That was that the Code of Conduct scheme was available under the law as a good way of demonstrating compliance with the law. And the other thing is that the fines started to get a lot bigger, and that made everyone pay attention. They can be up to 4% of your worldwide turnover. And that was really kind of what changed things in 2018.
Thanks, Katie. So how do you see the legal sector embracing the approval of this code of conduct?
So law firms, when instructing private investigators, are always going to be conscious of the need to comply with data protection law. And anything like the code that can give a really good indication that the compliance with law has been assessed and independently verified is definitely welcomed. There was a lot of fuss and excitement about the code being approved, on my social media and amongst my data protection friends, because it was the first, it really is groundbreaking. It was the first code under the GDPR for any sector in the UK. And so people are kind of recognizing that is, an important development, and it's a really good new way of demonstrating compliance with data protection law.
No, agreed. And how do you think that the legal sector will embrace this and look to appoint and instruct code members? That's the transition period. Because it's new, it's the first code that's been approved by the ICO. We as the professional investigator are now in this phase of seeing whether the code is going to be rolled out and accepted within the legal community.
I can see law firms and others appointing investigators having this as one of the kind of essential prerequisite questions that they ask, of anyone that they're asking to handle personal data, as part of their due diligence when selecting someone. Are you a code member? Can you prove it? Can you show us what you do in relation to data protection law? So I think code membership will become, the question about code membership will become a really important part of due diligence, supplier due diligence, effectively. And I think some of the paperwork that code members will have to put together, that can be easily given to law firms to demonstrate some of the accountability requirements that you have under data protection law.
I, for one, have seen over the past few years, especially after the introduction of GDPR, law firms altering their terms of engagement to include the processor or the controller and other acts within that. So, who knows for the industry as we evolve whether code membership could be a requirement moving forward.
I think that's right. And actually the code itself talks about, without getting too sort of nerdy about data protection law here, who is a controller, who is a processor, what are the indicators? I think those kind of, the fact that this has been approved by the regulator, the ICO, these potential roles, that could well be then reflected in people's terms of engagement. And that's something that's quite likely too.
Thank you. Thanks, Katie. So, Katie, drilling down into day-to-day practices for law firms, how might the code impact the law firm instructing professional investigators?
Anyone who instructs someone else to process personal data, to handle personal data in some way, could potentially be responsible for what that other person does with that data. So it's really important for anyone instructing an investigator, or frankly anyone else, to be comfortable that they're going to handle personal data responsibly because of that potential liability, and also because it's the right thing to do legally. So I can see the code becoming important in terms of, if you are a member of it, it is evidence that you have thought about your data protection or compliance. It will certainly become part of how law firms conduct due diligence on the suppliers and the investigators that they might be appointing. So they will ask to see, if you are a code member, they will ask to see information about that membership, that it's still valid, that the monitoring body has assessed you recently. And that in itself will kind of, be evidence of good practice.
Do you think law firms and risk managers will review their due diligence processes when instructing professional investigators?
Yes, potentially. I'd advise them that they should be asking about whether an investigator is a code member as part of their due diligence when they are choosing to appoint an investigator. So it's one of the factors.
Thank you. Thanks, Katie. Tony, going back to the code in its drafting, what were the biggest challenges for you in drafting the code of conduct?
Well, the first thing I had to satisfy the ICO, the Information Commissioner's Office, was that the ABI was a representative body, and then that we had the support of ABI members to pursue the development of a code. So we've got over those two hurdles relatively comfortably. But then we were starting to see from outside the ABI a lot of finger pointing, like as if the ABI was bringing GDPR to the industry rather than it was the law and we had to comply, and this needed to be done because we had shortcomings in the way we were putting into practice the data protection requirements. So that was the biggest hurdles. Then we went on to the technical side of it. And the biggest hurdle was the processor controller role, the roles and responsibilities. And there are some within the sector that take umbrage over the mere suggestion that an investigator could be a controller. But that's the truth of the matter. It's all down to the activities that the investigator performs, some of which I like to describe it as going off piste. You get your instructions, your start position will invariably be, particularly when your client is a law firm, will be the processor. But we go off speculating with some lines of inquiry, some of which prove to be of no interest and of no value. But we don't know that until we go down that road. And quite often in that going off piste, we determine the purpose and means for that part of the processing. And that could put the investigator in the role of controller for that part of the processing until they get back on the slope. So the individual that the investigator might be investigating, processing their personal data for that part, has rights also under GDPR. So who do they look to enforce their rights? Well, it has to be the controller, who the investigator, who's the controller, because of course their legal client will probably have no idea that they've gone down that road. Now, the investigator could stop before going down that off-piste, revert to the law firm client for specific instructions, but quite often it's impractical or time that just doesn't permit. You have to think on your feet and pursue certain lines of inquiries.
Can I just add a couple of points to that? I think Tony made a really important point there, that the code actually doesn't impose additional obligations. All it does is give, an officially approved, a regulator's approved view of what those roles and responsibilities and how to comply with data protection, or what those things are in this context. So it is not, aside from the need to kind of, work with the monitoring body and to become a member, there's a little bit of work in there, but it is not otherwise, there's no additional data protection or obligations. All it's doing is giving you a really handy kind of step-by-step guide as to how to apply those. And actually, even if you're not a member, it's really useful to look at what the ICO has said as approved in there about, for example, some of the details of how data protection law does apply in this context, who is a controller, who is a processor. Without getting into too much detail, it's a really useful guide to how to comply in this particular circumstance.
It's a really, really good point, Katie, because the GDPR law is the GDPR law, and the code of conduct is a guide that's been approved by the ICO. So you're right, for the professional investigator out there, the law's there anyway. Yeah. And what the ABI has done with this approval is managed to put it on a document that it makes it easier for you to interpret, to follow, and there's a guide there. And it also shows that you're a safe pair of hands to your legal or whichever clients are appointing a professional investigator, that you're going to demonstrate compliance with a law that exists for everyone.
Yeah, absolutely. And there's a huge kind of indication that you can trust someone with personal data if they've gone to the trouble of actually becoming a member. It's fantastic.
Thank you. Thank you, Katie.
If I could just add to that, Mike, the safe pair of hands is becoming a code member, because, of course, there's a lot of confusion also within the sector that, in fact, this is something like a code of ethics that an organization writes, and maybe the members comply or give it just lip service or put it on their website without even having read it. The code membership demonstrates not only the compliance, but that they've proven to the monitoring body, an independent monitoring body, that they are compliant. For example, that they understand and communicate to their client the role that they're playing on the receipt of those instructions.
Thank you, Tony. So, Tony, could you explain why compliance with GDPR is essential for the investigation sector?
Well, it's more than essential. It's a legal obligation that you have to do it. That's an end of it. How you go about doing it, that's where the code of conduct comes into play, because it is a good practice guide. and it says this is how you might be able to interpret what the GDPR law is telling you.
So, and Katie, would you add your legal view on how the code gives law firms and clients additional assurances, especially in contentious situations?
Data protection can become a bit of an Achilles heel. If there is litigation going on and personal data is being handled unlawfully, it can be quite easy for the individuals who are affected to make a complaint about that, to bring that as an additional element of the claim that they're already bringing. So it's quite important to get right, not only because it is a mandatory legal obligation, but because it can become a bit of a, as I said, a bit of a kind of weak point in an otherwise strong case if you've obtained evidence or in some way acted that's not in accordance with data protection law. That's something that we often see kind of playing out in contentious situations. For example, people will bring subject access requests or add data protection elements into their existing claims.
Right, understood. Thanks, Katie. And Tony, you touched on the monitoring body earlier. Could you explain the role of the code's independent monitoring body and how it enforces trust and accountability?
The monitoring body comes from a company that is already accredited as an auditor, for example, by UCAS, and then they have to get that additional approval from the Information Commissioner's Office. And they step in, they will look at the code, particularly its criteria, and then go through it step by step to ensure that the applicant for the code membership fits that role, whether it be fit and proper to be an investigator, and that they have understood and demonstrated in practice what the code actually suggests the compliance of GDPR.
Just to add one thing to that, it's important to say it's not a kind of get out of jail free card. If you are a code member, that doesn't mean you are guaranteed to be free from fines or litigation around data protection law. But what it will be is an indicator that you are compliant. And if you are a code member, the ICO, the regulator, has said that it will take into account your membership when it is assessing whether to fine you or whether to take any enforcement action against you. So, it's not a guarantee that nothing bad will happen, but in addition to the fact that it shows you're taking your responsibilities seriously, it might also stand you in good stead with a regulator or with a court down the line if there is a complaint or a claim.
So an investigator going through code membership, code status, like you said earlier, it's not a get out of jail free card. However, if you're put into a situation maybe beyond out of your control and you're a code member, you may be looked upon favourably by the ICO.
Yes, it's not a guarantee, but yes, that's an indication that they will look upon you favourably in that case.
Because you've demonstrated accountability, the training, the signing up to the code criteria and its benefits.
Absolutely. Yeah.
Thanks, Katie.
The code actually provides a mechanism for the monitoring body itself to look at any infringements, and it provides a matrix of how it would tackle that. And it's clearly not going to involve any fining, but the main action that the monitoring body is likely to take is retraining on GDPR that the ABI provides.
Yeah, so there is an issue. You might be able to leave the regulator out of it entirely, and they might be comfortable to let the monitoring body resolve that issue.
Oh, right. So it's getting the investigator to think, actually, applying for code member status is the closest step I can to be held accountable under GDPR.
Yep.
And demonstrating that in front of your clients. I mean, if the legal sector embrace that, then that's the objective, right?
Yeah, and the legal sector certainly, and all kind of all organisations are looking for kind of objective, verifiable ways of ensuring that the people that they ask to hold personal data, use personal data for them, are compliant. So things like ISO certifications, other kind of assurances, they're becoming quite standard as objective benchmark for, a way of auditing whether someone's doing what they said that they are. So this is another example of those kind of benchmarks and standards that are being used and becoming quite widely adopted.
Just while we're on that topic, would you see the legal sector, say, instructing code members to think, right, that's my DD done, I've pushed the problem to the investigator now and taken myself out of any risk?
I think that law firms will still ask further questions. I don't think you can just say I'm a member, that's all you need to know. If they're doing the right thing, that they might still have further assurances, further questions. They might want certain things in the terms that they use, but you will probably minimize the amount of additional information that will be needed.
Thanks, Katie. So, Tony, what are the practical benefits for investigators going through the process and signing up to code status?
Well, the code and the work that the ABI undertook in developing the code identified some key issues, and it wasn't made up. This was things that we pulled out from what we learned during the workshops that investigators were struggling with applying GDPR to their methodologies and their understandings of their responsibilities and obligations. So the code membership enables you to be familiar with those key issues and also how to address those key issues. Other benefits, of course, is the demonstration to your clients of your willingness to be accountable to the monitoring body in the work that you do and that you are compliant. Also, the general approach of your agency. And I haven't mentioned it before, and I've made reference to the word agency. It's the agency, the company, that would be the code member. However, the assessment is done by the monitoring body on a principle of that agency, because, of course, one of the requirements is that you, as the principal of that agency, are fit and proper to be an investigator. For example, you have an acceptable DBS search result, and I say acceptable, it's not a zero tolerance. There's recency and relevancy factors to be taken into account, and following very much along the lines of the ABI's criminal conviction certificate policy statement.
Fantastic. Thank you, Tony. So I just want to close on some reflections. We've spoken about the Code of Conduct, we've spoken about GDPR, we've spoken about professional investigators and the legal sector. What's next for the industry in raising standards? Let's go to you, Katie, first.
I think it's worth taking a step back and thinking what an amazing achievement this is. In my world, and appreciate, data protection land isn't for everyone, but this is a really big deal. And the fact is that the investigation sector is the first that has passed one of these codes. So that is real indication that it is committed to high standards in data protection. I think I'm obviously looking to see what other codes are approved, but for this sector specifically, I think people starting to get on board and becoming members, the first kind of monitoring body assessments being done, it's only going to really kind of mature standards for the industry, for the sector. And sort of hopefully lead to really high data protection standards and good levels of trust for everyone.
Thanks, Katie. Tony?
The existence of the code has or should have a very, very significant impact on the legal profession. Processing personal data is what we as investigators do day in, day out. That is our core activity in the work that we do and the services we provide for the legal profession. Nowhere throughout Europe does any of the investigation sectors, even in the countries where there is licensing, do they play such or place such importance on data protection as we have done in the United Kingdom. And I think that whereas there's a lot of talk within our sector, and there has been for 60 years, about regulating the sector by statute, and it is something that has been considered somewhat complicated and difficult by governments, and there is no political will to regulate by statute the sector, but it does keep coming back on the agenda. This deals with not only what licensing would potentially want to achieve, it really does do it, and that's protect the public from the real causes of potential harm by protecting the data. Everything that you can see throughout the industry that's gone bad, the phone hacking scandal, all the terrible cases that you read about, if you look at the core activity, it was processing personal data. And if they had been code members and compliant with a monitoring body looking over their shoulder annually and being accountable, those things would not have happened. And if the legal profession can just look at that and take note, I think a lot of the problems that people think exist out there because we're not regulated are suddenly addressed.
Key takeaway for professional investigators:
embrace it.
Embrace the code. Same to you, Katie, for all the legal sector and anyone in the litigious world.
I'd certainly be saying to the legal sector to take into account, look into whether someone is a code member, ask them why not, ask them whether they've considered it if you are appointing an investigator, because it is such a high risk area of processing and people's rights can very easily get infringed. Looking to code membership is a really good indicator and one of the key factors that you should be taking into account when you are appointing someone to investigate and use personal data in that way.
Thank you, Tony and Katie, for your insightful and timely discussion. For all of our legal sector audience out there, this code is an essential part of your due diligence and defensibility toolkit when instructing a professional investigator. If you want to find out anything more about the Code of Conduct, please visit the Association of British Investigators website. The link is coming up on your screen now. And you've been listening to the Association of British Investigators podcast, helping you stay compliant and keeping you ahead of the curve. Thanks once again.